What do you do if you get arrested for a snap bag of drugs found in your car, but you had no idea it was there? This is quite a common experience following a vehicle stop, which turns into a vehicle search, and a so-called friend slips snap bags of drugs in the glove compartment or under the car seat without your knowledge. So what do you do if you get arrested? Well, first you need to call a lawyer, a good one, to advise and support you. When your lawyer arrives and hears your innocent instructions in a private meeting at the police station with you, they are going to have two aims in mind. A, to try and sort this mess out at the police station so you don't get charged and you're no further actioned. And B, if you do get charged, you have a credible and effective defence at any trial. In that private meeting at the police station with your lawyer before the police interview, your lawyer is going to explain the following 7 key points about what evidence the police must have to at least charge you with possession of a drug, the defences available to you, and more importantly, how to approach the police interview, whether to answer police questions or to say no comment. So listen carefully. 1. Your lawyer will explain the obvious. It is an offence in England and Wales to be in possession of a controlled drug like cannabis or cocaine under the Misuse of Drugs Act 1971. 2. Your lawyer will explain for the police to charge you with possession of drugs, they need evidence of 3 things. A. Evidence of your guilty conduct. B. Evidence of your guilty mind. And C. That you don't have a defence to the offence. 3. In relation to the guilty conduct, your lawyer will explain the police will need evidence that the snap bags found in your car has drugs in it, even if it's tiny traces in the snap bag. When it comes to the law on possession, this can either be physical possession, e.g. the snap bag of drugs are on your person, such as in your hand, bag or pocket, or constructive possession, e.g. the snap bag of drugs are in a place you control, e.g. your car or your car's glove compartment. So you don't need to be physically holding the snap bag of drugs to satisfy the guilty conduct of this offence. It is enough for the police to have found the snap bags anywhere in your car by law. So to get evidence of your guilty conduct, the police are going to ask you the following questions. A, do you own the car? And B, do you drive the car regularly? 4, then your lawyer will explain to charge you, the police will need evidence of your guilty mind. For drug possession, the required guilty mind is not what you think it is. It is not you knew the item, the snap bag contained drugs, but only that you knew you had something in your control. That is, you knew about the snap bags in your car. So to obtain evidence of your guilty mind, the police are likely to ask the following questions. A, did you see any snap bags in your car? B, did you touch the snap bags? C, did you put the snap bags in the glove compartment? D, did you see any of your friends with a snap bag? And E, did you see any of your friends put the snap bag in the glove compartment? And you should know there is a strong presumption of knowledge you knew about the snap bags because it is in your car and in your glove compartment. 5. Your lawyer will explain where the police have on the face of it a case against you, evidence of your guilty conduct and evidence of your guilty mind. The evidential burden shifts to you to raise a defence, without which the police will have enough evidence to charge you. While the police have to prove you had possession beyond a reasonable doubt, you must provide some evidence, enough evidence to cast doubt on whether you knew about the drugs at all. In reality, this means to try to avoid being charged, you will need to say something of your defence to the police if you're trying to avoid being charged, or at least put forward a defence if you need to rely on it if the case proceeds to a trial in the future. 6. So based on these specific instructions, you had no idea of the drugs and the snap bags being in your car. Your lawyer will explain 2 key defences you could raise. 1, which aims to undermine evidence of your guilty conduct, and the other, which aims to undermine evidence of your guilty mind. A, the snap bag of drugs was placed in a part of the car you don't usually check, in the glove compartment, for instance, to challenge constructive possession. And B, your primary defense is the absence of knowledge defense. You genuinely didn't know about anyone having snap bags of drugs in your car, and knowing that the snap bags of drugs was put in your car glove compartment, hidden and unknown to you. Finally, point 7, how should you respond to police questions? What advice would you expect your lawyer to give you? Answer questions or say no comment? The starting point in many cases is you have a legal right to remain silent and say no comment to police questions. But you can see why saying no comment might not be the best course of action where you genuinely had no idea of the drugs in your car. In this scenario, silence in a police interview can harm your case and defence, especially if the case goes to trial. Because under the Criminal Justice and Public Order Act 1994 in England and Wales, if you don't mention something during police questioning that you later rely on in court, the court may draw adverse inferences. That is, you've just made up your defence before trial to fit the police evidence. So providing an innocent and reasonable explanation early on could work in your favour. Providing evidence, the recorded police interview, by answering police questions that you had no knowledge or control over the drugs, and that others had access to your car gloves compartment, and others must have put the snapbag in your glove compartment, can help raise a strong defence early. And this can help create doubt about your control and knowledge over the drugs. And this strategy might lead to no further action being taken against you. Case closed at the police station, and some tough words with your friend afterwards. Remember, each case and advice is fact specific, so listen carefully to your lawyer's advice and then make the call whether to answer police questions or not. Feel free to comment, follow and subscribe for more.